They don't have to use your real name.
All you
We
got
are
to do,
live, it says.
right.
So, see, there you go. It's a Facebook issue with Zoom because they've been trying to take over. Now, this is a browser-based software that doesn't need software to go through Facebook.
Right.
Understand? So that's why it's allowed.
I pulled it up and listened to part of a tutorial while we were trying to figure this out.
Yeah,
I need to open up an account so that I can have more control. So I'll figure it out so we can keep doing this because they're not stopping us. So
I love it. We're live right now.
Great.
So let me see what I can do here. Let me get us on the radio. Well, I can go on a couple minutes early, right? We don't care about that. You want to go on exactly at the 2, or you want to go on a little bit before 2?
Whatever works out.
All right. Well, anyway, Coach Neighbors, it's a pleasure to have you again. And I just wanted to say that it's a pleasure having you every week here. And I so appreciate what you're doing. I so appreciate how you're doing it. And I know homeowners that are going through such a tough time right now here in Hamilton, New Jersey. I just want to give you an idea. We're going to get a 30% tax raise within the next year. I don't know anybody that can sustain that.
30%?
30%. That's not 3%. That's 30%.
Wow.
And then everything else, of course, is going to go up because of COVID or whatever reasons.
Yeah.
Everything's related to whatever it is related to is going to go up. And, of course, I told people before, if you didn't pay your mortgage then, a forbearance doesn't mean they're going to forgive you, right? A forbearance means that they're putting it at the end of the loan, but you still owe for all the months that you didn't pay. So now they're going to come after you for all them months together. If you don't have that money, sorry.
And I had a guy contact me.
They're going to need you, man. They're going to need you.
Yeah, I had a guy contact me from Maryland, and he's been helping people down there, and they kind of jammed him up. And so I'm helping him get himself unjammed. And he said that he can see that they're already lining everything up. So when they lift the moratorium and all of this stuff, when they lift that stuff, they're going to be going after people. And the people that they're going to be slamming is going to be the people that didn't use that time to put themselves in position to fight back. Right. And the problem that they're going to have is the homeowners aren't going to have enough time to defend themselves in court, because the attorneys are going to come in and say, hey, they've had all of this time or whatever. And the homeowner said, well, there was a moratorium. Well, that moratorium stops them from throwing you out the door, but it don't stop the clock from ticking on the time that you have to respond. Very true. That's what people are missing out on. That clock is still ticking, even though they can't do anything to you. And then when it's all said and done, the clock's ticked out. And now they're moving to evict you. And they're going to be saying you've had plenty of time to do stuff, but you haven't done anything.
Exactly. You got to show that you have some type of play in the game, or you're not going to get anything out of this. You're just going to lose everything. And that's where a lot of people are, in fact, going to be, unfortunately. Yeah. And, that's why they're going to need you. They're going to need you more than ever, and in droves, because it's going to come quickly.
And that's why we lowered our price. Before the pandemic started, I had already lowered it from 17 something to $850 and our lawsuit packages. And then once the pandemic started and I could see all this stuff and how it was going to affect everybody, then I decided to go ahead and drop the packages down to $400. And when I qualify to host ads on my YouTube channel, then I'll even lower the price even smaller, because the money that I'll be generating from hosting those ads is going to be substantial, and it's going to be and I'll be able to invest that money into the project. And the project is helping people get to stay in their house. So it's become my life story here. So that's what it's about. So anyway, welcome everybody. I'm Coach Neighbors. Advocates for Justice, Paralegal Service, Foreclosure Defense, and more. And Advocates for Justice, Paralegal Service, we are different, and we prove it. So today we're going to talk about one of the things that most everybody has to suffer through if you're in court. And that thing is the judge's misconduct. That's what we're going to talk about today. Oops, I lost the window that I need.
That's okay.
So my website's at winincourtnow.com, and that website has the wrongful foreclosure lawsuit packages for both judicial and non-judicial foreclosure defense, and it has other packages too for to smash credit card lawsuit, third-party debt collectors. And my new online course is titled Wrongful Foreclosure DIY, and it is the ultimate guide to filing your wrongful foreclosure lawsuit in federal court to defend your property. So, does the judge have complete immunity? You will learn how to use their plays against them, and that's what I'm going to teach you how to do. If you get in my program, you're going to learn how to use their plays, the plays they use against them. And this concept I learned, I played football for the University of Kansas in the 80s, in the early 80s, back when Nebraska was like totally badass. And yeah, they had some of the biggest white dudes I've ever seen. And one year we were playing them, they were killing us. I think the final score was in the 70s, and that wasn't our score. And our head coach was pissed. And so I was over there listening to him one day, and he was telling the other coaches, I can't believe those sons of bitches, they come down here and they run our own plays against us. And boy, I thought, wow, man, they're running our plays against us. They must be pretty good. So maybe that's what we need to be doing. So if it's working, we need to run their plays against them. And that's what I'm going to teach you how to do, how to run their plays against them. And if their play smashes everybody that they've been using them against, then we want to use their plays against them. And now you can sue them in a higher court for suing you. Yeah. I always tell people when you get in my program, you're going to learn how to have some fun before this is over with, because you have no idea how much power you have. We have no idea how much power we have or how to access it and use it in our behalf.
Phone call, Coach Neighbors. Do you want it?
Sure.
Let me get him on first. Okay. You're on Coach Neighbors' show. Who's calling?
Yeah, my name's Noel. I just called in. I was hoping to listen to the program, but since I guess I'm on the air.
You're on the air live. Go ahead.
I should tell you that we have just the problem that Coach Neighbors is talking about. A corrupt judge violated us in court, and the attorneys just hell-bent on illegally seizing our property, not for the minimal acreage that our 280-acre Kansas farm constitutes, but for the recently discovered, promising, and virtually untapped oil reservoir lying beneath the farm's surface is what they've long coveted and are after.
So this is Steve?
That is.
Hey, Steve, how you doing, man?
I'm all right, Coach. How you been, bud?
I'm doing pretty good.
You know, the last action that we took was the filing of the jurisdictional challenge with the affidavit. And, of course, it's a notice that's addressed to the court that the plaintiff, lender, bank, is to, prove that they've got standing in the jurisdiction. And, the judge just shut it back and said, it's timely unfiled. You can't file it. You had your chance and it ran. So,
well, Steve, number one, that jurisdictional challenge was an affidavit is for the attorneys to respond to, not the judge, because the judge is not the one that can make a determination whether he or she has jurisdiction. And once jurisdiction is challenged, and it says right in the document with the case law, once jurisdiction is challenged, it has to be proven on the record. Now, if the judge is doing what he's doing to you, that's what we're going to talk about in this show today. So hopefully,
that's what I wanted to hear, because that's where we're at. I realized that the plaintiff lender was to respond, but the judge just
no, their attorney.
This out of time.
Steve, the attorney has to respond. The lender. So the biggest mistake that most people make in fighting foreclosure is they think the lender is the one foreclosing. The lender's not. People have to understand that the mortgage loan and the mortgage is different from the foreclosure. It's not the same thing. It's not the same process, and the same players are not involved. In the mortgage, the lender is involved or whatever, but when it gets to the foreclosure process, the lender has already charged it off the books and did the charge off and claimed it on the insurance. And at that point, anybody that knows about the GAAP or accounting principles will tell you that after you do a charge off, there's no place left on the books for you to add any additional income from what you charged off. And not only that, once you do the charge off and you make money from it, it's income tax evasion, and it's also insurance fraud, because there's no place to claim that money after you do the charge off. Now, the issue with the judge, we're going to talk about that in the show, Steve. So if you have any questions after we get started, you can call back in after we get done with the presentation about the judge, okay?
All right, I can call you. But yeah, I did address it to the attorneys for the plaintiff. I did.
I didn't hear what you just said, Steve.
Yeah, he said he's going to contact the attorney. We're getting another phone call. Do you want the other phone call?
Yes.
Okay. Let me get the other phone call, guys. Hold on.
Sure.
Let's see. Hello, who's here at the Coach Neighbors show?
Hey, Jan, it's Tom Kibler.
Hey, Tom, it's Tom Kibler. We can't hear Tom too well. Tom, go ahead.
I'm at your website trying to figure out how the heck I can see the show. I can't find it.
You're going to have to email me off air on that, Tom. All right? Okay. Sorry,
hey, Tom.
Coach Neighbors, go ahead.
Hey, Tom, how you doing, buddy?
He hung up.
Okay.
Yeah, he hung up.
Okay, so let's just go ahead and move forward here so we can get to the hopefully, actually, this is a good problem to have, so that's kind of cool. Okay, but before we proceed, we have to look at the differences between the conventional and the non-conventional strategies, foreclosure defense strategies. And the reason that we need to do that is because once you understand the two, then it's a lot easier to understand what I'm going to help you, what I'm teaching you how to do. So in the conventional foreclosure defense strategies, you generally have three options: loan modification, short sale, and bankruptcy. The loan modification is nowadays used to disqualify homeowners because you have to expose yourself by providing your financial information. And usually what happens is the bank finds out that you have more income going out than you do coming in. And then they decide they don't want to work with you anymore. But they won't tell you that. Okay, what they tell you is, we need you to send those paperwork over to us again. We didn't get this form. For some reason, this is not showing in our computer. And it just keeps stalling you along the way until they get themselves in a position to go ahead and start trying to steal your property. That's what the loan modification is used for. The short sale, we won't even spend a minute on that. Okay, the short sale speaks for itself, but the one thing that attorneys don't tell people about the short sale is that about half of the states have a deficiency judgment. And what that means is after they get done giving your house away for whatever they want to give it away for, they can come after you with a deficiency judgment, a third-party debt collector. And they can actually attack your bank account, your wages, your garnish, the whole ball of wax. So that's wait a minute. There's a fourth option for the conventional foreclosure defense, and that's to move out. Yeah, I had a lady tell me that after spending $12,000, the attorney told her she should just move out. He don't understand why she's fighting so hard to stay in the house. I wouldn't have been able to handle that very well if the attorney I just paid told me that. There would be some problems. But that's the fourth option. Now, people don't realize that when you go into the conventional foreclosure defense, you're defending the fraud in their claim, in their false claim. And people lose sight of the fact that the attorneys are the ones that structured the conventional foreclosure defense program. Think about it. They structured it. Why is it that attorneys won't tell you from the gate that you can sue for a wrongful foreclosure as soon as they post something on the public record or give you a document saying you're behind? You can sue them. And what you're suing them for is all the stuff that we just got done talking about. That's the difference between the conventional and the non-conventional. In the non-conventional foreclosure defense program, you will be suing the attorney in federal court for filing the foreclosure against your property acting as a third-party debt collector. And when you add the attorney as the number one defendant to your lawsuit and their law firm as the second defendant, it's a problem. It's a problem for the attorneys because the attorneys will have to hire outside counsel to help them. And they have trouble with that because as soon as the outside counsel finds out that you're suing the law firm and the attorney for wrongful foreclosure and breach of contract acting as a third-party debt collector, they don't want to get involved. They do not want to get involved. And the reason they don't want to get involved, in my opinion, is because they're doing the same crap to people. So now the attorneys have to get the judge to allow them to violate the rules and defend themselves and the law firm in court. And once that happens, then you file your motion your demand to strike the attorney's notice of appearance. And if the judge denies that, you file your motion for reconsideration, which is what we're going to talk about later today, how to do all of that. And you back the judge up in the corner. And what you want to do is you want to set yourself up for your appeal at the gate. And you do that by backing them in the corner with this little process that I just told you, where you're making them, you're using their own rules against them. That's how we do it. Now, once you get yourself in that situation, then you want to use that decision the judge made, allowing them to skate the rules. That's what you want to appeal. Oh, hell yeah, that's what you want to appeal. Because you got clear as day right there that they're violating the rules. You got the case law, everything right in there. That's what you want to use for your appeal. Soon as the judge violates you, you want to take action. Now, my question is, which strategy sounds best for your family? Going in and filing stuff in their case that they filed against you, which is fraud. So no matter what you do, you're going to have fraud. At the end of the day, you're going to have fraud, and it's just fraud from the beginning. Or filing your own case against the person who signed to start the foreclosure against your property in a higher court. I think the second strategy is the one that I would like to use. And what I'm helping you guys learn is exactly what I would do if I was in this situation again. Yeah, I was in it before, and I didn't learn all this stuff fast enough. But I know it now.
Neither one of us.
Yeah, and I'm a sore loser. You can ask anybody that knows me. I'm a sore loser. If you want to be in my program, you got to be willing to do whatever it takes to make this work out. Okay, so I got a question for you guys before we go any further. Who do you guys think is in charge in the courtroom? The judge or the attorney? So I'm going to give you just a few seconds to think about that. Who's in charge in the courtroom, the judge or the attorney? Okay, time's up. Pencils down. For those of you who answered the judge, you just got hosed, and you need to go home and start packing your stuff. I had another word in there, but I changed it to stuff because I want to try and be nice here. You need to go home and start packing your stuff. Now, I know some of you are thinking, okay, that shit is not funny. And it's not funny. But it's the point here is, if you failed to make the right call on this, you're going to be packing your stuff if you're lucky. If you're not lucky, they'll be throwing your stuff out on the freaking front yard or out on the street and putting a new lock on the door while you're going to work. Yeah, believe me, I have stories and I can tell you, and I know they're real because the people are in tears the whole time they're talking to me on the phone. So the attorney is the one. So the attorney is the one that calls the shots in court. And by the time they drag your happy ass in their court, they've already figured out what they're going to do to violate you. Now, before we get into how we're going to handle the judge, and I want to remind you guys to subscribe to my channel so you can get this free information and tips and strategies and resources that we have to offer. And make sure you click the bell so you don't miss anything when class starts. And I'm going to say again, don't forget to ring the bell, because if you don't ring the bell, you won't get notification when I'm on, because I try to be on every Saturday night, but I'm on other times. And a lot of times there are other things that dictate when I have time to be on because of all the stuff that we're doing. Okay, let's get to why we're here. So, Gene, can you see the counter?
Let me see. Hold on.
I can't see the counter right now, and I didn't want to switch back. If you can see the counter, it'd be nice if you could just make a little note of.
I can see the counter, sure.
Okay, of the minutes that we're at, so that I can put those in. So
yeah, 22 minutes. 22
okay.
minutes.
So the judge's scam. I didn't know where to start with this. So here's a few things that you need to look out for. And then we'll get a little more into how to look out for yourself when you're in the situation. So here's a few of the scams the judge used to illegally dismiss your case. The number one scam, in my opinion, is the magistrate judge. Either the clerk or the district judge will hand your case over to the magistrate judge and have the magistrate judge look at it. And then the magistrate judge decides that, especially if you have my stuff, that you haven't made a claim that you can, made a claim that you can get money on. So they're just going to move to dismiss it. So the magistrate judge writes a report and sends the report back to the district judge to dismiss your case for failure to state a claim. Well, the problem with that is the magistrate judge does not have jurisdiction to be involved in your case at all without consent from all parties. Written consent filed in the case from all parties. But people don't know this. So they just go ahead and do it. And I think they do this. One of the things that they're avoiding is the liability to the district judge. Well, that's what they are trying to avoid, is liability to the district judge. What they're going to say when you jam them up about this is, well, you're in a hurry to get your case adjudicated and you want to, blah, blah, blah. So that's what, well, in my program, we ain't in a hurry to go before the judge. We ain't even trying to go to court. What we're trying to do is get everything on the record that we need to make them not want to have a hearing. So that's the way we roll with that. So the way I would handle that is I would just wait until after the magistrate judge gets involved in your case and does all this stuff. And then I would jam the magistrate judge. At the end of the day, it don't matter who you sue, as long as you're suing somebody for what they did to you. And that's the way that you have to look at this. Now, the problem here is the magistrate judge gives the district judge the report to dismiss your case. So your case is being dismissed not based off of a judicial decision. Your case is being dismissed based off of an administrative freaking report. Think about that for a second. How many of you guys had your case dismissed because of the judge's report? And then the other judge dismisses based off the report and not a ruling of law that he's come to from facts of finding and rulings of law. Now, those are the two things that are supposed to be used when the judge makes an order. So if that's what they're doing, and to me, it's simple. They have you in an administrative court. And in an administrative court, you have no rights. The administrative court is not part of the Constitution. So you don't have no rights. And they pull a wool over your face, and people say, "Oh, I can file my appeal." Well, you can file your appeal all day. The only thing you're going to get out of appeal, if you get anything, is they'll send your ass back over to the judge's den so they can finish you off. Now, the way it should happen, if the appeal shows that something happened dirty, they should just dismiss it with prejudice from the appellate court. Or at least that's the way I see it. But, I'm not a judge. So the other scam is the judge claims a lack of jurisdiction, the federal judge. Because remember, you're going to sue. Now, people need to remember, federal court don't want to have state courts crap in their court. So they're not going to tell, "Come on over, we're going to help you kick the butt." No, they're going to be trying to get out of putting their butt in the middle of all this poop slinging program anyway. And the first thing the federal judge is, "Hey, we don't have jurisdiction because of the Rooker-Feldman doctrine or because of the Colorado River or whatever." Okay, all of these doctrines are BS. And they're BS because, like in the Rooker-Feldman doctrine, they say, well, they don't want you using federal court as an appeals court. Well, that's because the plaintiff, lost but in state court, you're not the plaintiff. You're never the plaintiff in state court. You're not going to file a lawsuit against yourself. So that whole doctrine is BS. But when the judge uses it, people freak out. "Oh, the judge knows everything and I have no chance." Dude, the way to tell when bar members are lying is their mouths moving or their hands writing something. I just threw that part in. Mm-hmm. So don't, because the judge says it, that don't mean squat to me. Okay. And people don't realize all you got to do to keep these people in check is look up the laws they're supposed to be following. They ain't following them. They ain't following them. Now, the judge is real slick. And what they do is they will answer on behalf of the attorneys. And if you don't object, then they'll be dismissing on behalf of the attorneys. They're real slick about feeling around in there and trying to figure out how they can grab that handle and get their hand on the steering wheel. And once they get their hand on the steering wheel, then they're going to steer you right out the door. Now, we've had judges that will postpone the hearings or continue it, even when the attorney's in default. I had one judge that's flat out responding for the attorneys, and they told the client that what he just filed, the jurisdiction challenge with an affidavit, was ridiculous, and he wasn't going to, So at that point, I would have been go ahead and file my notice of claim against the judge. They're going to continue to throw you under the bus until you earn their respect. So the judge must be recused in any proceedings in which the judge's impartiality might reasonably be called into question, or the judge has a personal bias, prejudice, or concerning the subject matter or the party. Now, people freak out when we start talking about the judge, because they think the judge, you know what? No. The judge is supposed to follow the rules and the law just like everybody else. And if they don't, then they can be held responsible civilly. So the judge usually fails to file the order finding of facts and conclusions of law to support their ruling. And if you don't have that, you're an administrative. They just took you through an administrative hearing, which you have no rights, and they don't care. And this is the evidence that you're in an administrative court, which is not connected to the Constitution. So if the judge is going to trick you into their administrative court without your knowledge or consent, you must hold the judge accountable with the administrative rules. It's pretty simple if you step back and think about it. But a lot of times people miss this stuff because they get so emotionally wrapped up in the attorney's case and what they said against them and all of that. So the number one thing, and most of you, if you invested in the lawsuit package, most of you have the document that you need, the notice of claim that you need to stick in a judge's face. And that notice of claim is one of the main things that's in the notice of claim is you are accusing them of violating the Administrative Procedures Act of 1946. This is badass. And I'm telling you, if you're trying to research this, you're going to have to put the Administrative Procedures Act of 1946. If you don't put of 1946, then you'll pull up Cornell Law Library watered down BS about some crap that the bar members put on there that don't have anything to do with the real thing. Now, what this is, the Administrative Procedures Act, and this is actually enacted in 1946. I looked it up because remember I told you, a law is not a law unless it has an enacting clause, unless it has a title, and unless it has a body. If it does not have those three things, then it's a statute, a rule, or ordinance, or some other bull crap that's from the corporation, and it's not something that you have to follow. I looked it up. The Administrative Procedures Act was actually enacted in federal law in 1946, and the reason for the Administrative Procedures Act is that the Constitution, the reason for this act is they wanted to make sure that these corporations had their policies and their procedures in line with the Constitution. That's what this is about. And this is huge. I used this to help a friend of mine that was traveling through the BLP. And believe me, when the BLP people got this document, they showed up with 3 people from Suits showed up to find out what was going on. They don't. Now, what makes this powerful is that you can't get money from the Administrative Procedures Act. So you want to throw in their constitutional right violation and some other stuff, whatever. But this, if you are given an award in administrative court on this situation, you can force the corporation to change their policies and make them in line with the Constitution. And you know they can't do that. If they do that, they ain't making no money. So they are not wanting to have this conversation about this. So I think people don't realize how powerful that document is. Now, it's written up as a notice of claim. Now, that is the actual claim, because that's the way I do it. Most people, when you do a notice of claim, they write notice of claim or whatever, and that's all they put on it for whatever, and it's less information. For me, we ain't trying to go to court. So we want them to know everything that we want them to know if we went to court. So all of that is put in that notice of claim. Now, it's written as a letter format, but the information that's in the lawsuit is in the notice of claim letter. And you're letting them know that you're putting the judge on. Now, the goal of this is to force the judge to reconsider and let you pass, as opposed to having to address all of this stuff, in court. So when the judge provides an unfair advantage for a fellow bar member, he is obstructing the administration of justice. Now, the person that put me on this path years ago informed me of this just last summer. And what he told me was, when they're violating you, it's not, most people will look at it as a due process violation or whatever. He said, no. In civil court, you want to say that they're obstructing the administration of justice. And that lets all of those people, it puts them all on notice that you know what you're talking about. So that's what we have in the document. So the United States Constitution guarantees an unbiased judge who will always provide litigants with full protection of all rights. But we don't have that. So can a disqualification of a judge, can a judge be disqualified? Well, absolutely. And if the judge's attitude or state of mind leads a detached observer to conclude that an unfair and impartial hearing is unlikely, then the judge must be disqualified. And then I have the case law here from the Supreme Court. And I will leave the case laws when I make the video. I will put the case laws down below the video. And the courts have repeatedly held that positive proof of partiality of the judge is not required. Only the appearance of impartiality. And there's another case law here that I'm going to put down for that too. So should the judge issue any orders after he or she is disqualified by law, and if the party has been denied of any of his or her property or rights, the judge has been engaged in the federal crime of interfering with interstate commerce. And that's huge. Most people don't. So the judge's immunity, the judge only has immunity if the judge is acting within the judge's jurisdiction. Anytime the judge acts outside of his jurisdiction, the immunity is lost, and the judge does not have immunity, and can be sued in court very easily. Any questions?
None for me. I mean, it's appalling. Everything that you're saying is appalling to the people of the United States, and just let the courts destroy each other. It's horrible.
So I'm going to open up. So I have a package, a motion for reconsideration package. And today is your lucky day for anybody that has this problem. And this is why I don't say what I'm going to talk about at the end of the show. I wait until something comes up that's important. And this came up from 3 people. And I thought, you know what? This is what we need to be talking about, because this is the problem that we're having. So this package is going to be on sale for today only. So the listeners of Hamilton Radio will be able to get the entire reconsideration package for the crazy coronavirus low price of $100.
Ah, that's great.
This is an $850 package.
Great.
And it has the lawsuit that you need to sue the judge. It has everything you need to handle all of that. And I'm going to, for the rest of the day until midnight tonight, leave it at $100 freaking dollars. Now, I think for me, this puts my mouth where my money's at, my money where my mouth's at, because I don't like what attorneys are doing to people. And when I say attorneys, that dang sure includes a freaking judge. So this is what I've done about it. And I'm going to let this package go for, as a matter of fact, I need to go to my website and change the price of this. I think it's showing $300 on my website. So after the show is over, let me make a note so that I'm going to go to my website and change this to $1 million. $100. So now if you're in court or you got the judge in your face, and I had someone tell me today, or Steve just mentioned, the judge told him that it wasn't timely filed. That's the biggest BS. Whenever they open their mouth, they're lying, because jurisdiction can be challenged at any time, up to 15 years. And jurisdiction is the only thing that I help people challenge. And I have another person, Emilio. I've been working with him, and I hope he's coming around to realize that the jurisdiction is the only thing that we need to challenge. You know, having recordings of the people talking and the attorneys doing all this other stuff. The bank is not in it right now. When it gets into the foreclosure, it's just the attorneys. And I'll tell you right now, when you get this one thing right and have the attorneys as the number one defendant in your wrongful foreclosure lawsuit, you will be driver of the bus. And that is no joke. So give me 1 second. I'm going to open up the file and show you guys the documents that's in this package. But give me 1 second, okay?
Go ahead, take your time. While Coach is doing that, I'm going to be putting up on the screen again, guys, what I just put up there before, which is his YouTube channel, which says Foreclosure Defense Paralegal Service. I want to ask you, if you haven't subscribed, to subscribe. If you have subscribed, thank you. We're trying to reach 1,000 subscribers or more. We want, if we can get 1,000, we want 5,000. If we get 5,000, we want 10,000. Listen, this is going to affect everybody that has a mortgage, everybody that's a renter, because according to what I was talking to people about mortgages, their landlords are going to be collecting their mortgages too, because the landlords aren't getting their mortgages from other people either. So this is like a trickle down the line, guys, type of thing. And it's going to affect you one way or another. So learn for yourself now, be ahead of the game in case it does come out, and be ready. And be ready to show other people how to do the same thing. Show them how to get to Foreclosure Defense Paralegal Service on YouTube and subscribe to his channel. Go ahead, Guy.
Okay, so we're going to open up share window here.
I'm an advocate for you. You know that. And I'm trying to do what you need to be done, because if you get enough subscribers, the packages, any packages will, whatever they be. But the point is, you'll have more people to help.
So can you see that share window?
I can, and I'm going to share it with you.
Okay.
There we go.
Okay, cool. So when you invest in one of my packages, they're all in zip files, because that is the only way I could. When I first started doing this, we just handed out 1 or 2 documents or whatever, and then you can see where that's the feedback, the real-time feedback allowed me to change the documents, add documents, and do things to block them from doing things. And so we have, like, the non-judicial foreclosure package has 16 documents in it. So, and people open it up and they start freaking out. You only have to worry about one step at a time. Okay, one step at a time. So in this reconsideration package, these are all of the documents that we have in there. So the first one, obviously, is the objection and notice of claim against the judge. So I'm just going to open it up and show you guys, because it opened up in the wrong screen, so I got to move it down here. So you replace the red font with your information. And remember, we're not responding to what they said you did or didn't do, okay? That's not what we're doing here. We're not responding to what they said you did or didn't do. So you don't have to add all of this stuff and all this other things in here, okay? We got in this document the stuff they don't want to argue. And that's what we're going to focus on. We're going to focus on the stuff they don't want to argue. And you can see here, you also need to change the red font to black when you're done, and delete any instructions. But you can see here, the notice of claim against Judge Hawthorne. Now you'll have to change that. That should be in red, but you'll have to change that. For violation of the Administrative Procedures Act of 1946, obstruction of the administration of justice, and violation of the Constitution, constitutional rights under color of law for making a determination without jurisdiction. Everything is based on jurisdiction or the lack thereof. And this is one powerful document. When the Assistant Attorney General for the state of Kansas tried to shut me down for, well, it took him, well, I think we were in court a year and several months. Then once I started learning about the lawsuit situation, and I figured out that these corporations don't give a crap about anything except when you can cost them money. So if they're foreclosing on you, why worry about answering to their stuff and jumping through those hoops and having them drag your ass in court a whole bunch of times when you can just sue them and make them have to go get an attorney too, just like they're doing you. And one of the things that I tell people is, you don't need to pay an attorney. You can screw up your case yourself.
So true.
And save your money. You know, with that being said, at the end of the day, you're going to make sure what needs to be filed is getting filed. And I have people who beat their head against the wall trying to have everything perfect because the court's going to make them hold it to the standard of a licensed attorney. Well, you know, newsflash, attorneys don't have no stinking license. So that whole thing is crap. And we talked about that a couple of shows back.
Yep.
They're holding you to a higher standard because attorneys don't have no license and they don't follow the rules or the law. Anybody want to argue that?
Guy, how do they get away with that if they don't have a license, right? And who holds them accountable for not having a license? Everybody holds us accountable for having a license for certain things.
Well, the program is set up. The licensing program for us is set up with people to enforce it, right? The cops will pull your ass over if you don't have a license. It's a problem.
Yep.
But for them, for the Fair Debt Collection Act practice, the credit card predatory lending, there's no agency to enforce any of that. So it don't matter. And the only option you have is filing your lawsuit to address the issue. So I'm just going to kind of scroll down here so people can see this. And I'm not going to spend a whole lot of time on it because, you know, what we already talked about, you know what we're doing here. We're holding a magistrate judge or the district judge. It don't matter which judge it is accountable for the stuff that they're doing. So let's go to the next document and take a look at it. So we got a reservation of rights, the jurisdiction, adamantly jurisdiction, elements for common law. These are all things that you have to have inside of your lawsuit. So the parties, and we have all the counts right here. So you're going after them for, you know, violation of 18 U.S.C. 241, conspiracy against rights, 242, deprivation of rights under color of the law, 18 U.S.C. 1505, obstruction of justice. Yeah. So you can see that this is serious. I put a lot of time in working this. I don't like what they're doing. And I used the same stuff when they were coming after me. So I'm not making stuff that I'm having everybody else use. As a matter of fact, I had a guy get one of my documents and he said, "Yeah, your name was in here." Yeah, I forgot to take that out. So the magistrate judge consent form. Now, I got this here just to show people, you know, when I'm talking about the magistrate judge consent, a lot of times people, you know, they're not sure of, you know, everybody thinks all the judges can do whatever they want. Well, no. So the magistrate judge consent form, and I'm going to show it to you. I was having this conversation with my wife one day, and she said, "No, the magistrate judge can do whatever." I'm like, "No." So we argued, and we just agreed to disagree. And then I Googled magistrate judge consent form and put Texas on there, and it pulled it up. So I copied this off, and I handed it to her, and she read it over it, and she said, "Oh my God, you're right." And I said, "Could you say that a couple of more times?" But, you know, and to me, this is powerful because this shows you right here what they're supposed to be following and what they're supposed to be doing, and they're not. And they don't until you hold their butts accountable.
Right.
And so people are calling me, well, the judge said, well, you know what? I don't care. You're in Coach Neighbors program. We don't give a crap about what the judge said. Only unless they tell you to be quiet in court. And they have to tell you the second time and threaten you with contempt of court. And I had that happen one time too. Until a judge threatens me with contempt of court, I'm just going to keep talking. Of course, then the judge said, Mr. Neighbors, you don't shut the hell up. Okay.
Yeah, but Coach Neighbors, don't you have the right to send contempt if not everybody's following the rules that they make the rules?
Absolutely. But unless you are in federal court in your lawsuit, none of that matters.
Right. That's right.
None of that matters. And that's what I try to convince people. People are like, well, no, I have an appeal filed in this court. I have like, look, if you're getting in my program, we don't do anything with what you're already doing. Okay. Because what you're doing is operating in fraud, because their stuff is all fraud. And it's going to be, you can do whatever you can take poop and you can shape it into whatever you want to shape it in, and it still stinks. So people need to realize that. And you can't connect the two. If you connect the two, they will discredit what you're doing with me. They'll ignore it, and they will continue arguing what they want to talk about. And that's the banking side, the system, and all of that. That's what they want to talk about. Now, let's take a look at the next document here. I want to go over there. Okay, the inventory, the notice to recuse. This is one of my favorite ones. I love this one. I don't know if you guys can tell I'm having a lot of fun today.
Oh, it's great.
Okay, it opened in the wrong window, so we're going to move it down here. And you're getting all of this for $1 million. I mean $100. That's what I agreed to, right? I get my zeros a little mixed up sometimes.
I get it.
So the notice of recusal of the magistrate judge pursuant to 28 U.S.C. section 455. And I put the section right there. You can go read it. I always tell people, don't take my word for it. I provide what you need to be able to do your own research and get right to the heart of the problem. And yeah, we've used this, and it's a problem. Usually I'll file this before I file the notice of claim, because I want to recuse the judge and jam them all up. I file this motion to recuse the judge, and then I file the notice of claim against the judge. And then the last thing that I file is the notice of appeal. Now, all of this has to be done within 10 days of the judge's decision. Actually, challenging the jurisdiction, you can do it anytime. But if you do it within 10 days, it relieves one of their main defenses. Well, you didn't do it in a timely manner. Well, I'm not a freaking attorney, so I don't have to follow all those rules that you have attorneys follow. And attorneys don't have a license. So we don't even want to get started talking about that, because that's a whole nother subject. So I can just put down here obstruction of the administration of justice. Now, what the judges do to people is bad. And they're violating everything that's in this document.
Coach, I'll be right back. I have to go somewhere.
Okay. So this document here is the motion to recuse the judge because of impartiality and the fact that he's obstructing the administration of justice in the case. And when the judge rules without jurisdiction, without consent or jurisdiction, then it's a problem. But it's only a problem if people step up and stick it in their face and make a big deal about it. And we have the affidavit here that we always put whenever we do one of those. And a lot of times we'll add the proposed order, but I don't have it on here. But the other document has a proposed order on it. So you can just take the order off of that one and attach it to this. You want to provide a proposed order anytime you file something in state court. So let's take a look at the next document here. Now, this document is the court form. Yeah, this document here, consent to proceed before the United States magistrate judge. This is the consent form, and each state has a form like this, and it's a little bit different. Sometimes they mail this form to you, and most people just throw it in the trash. And when you don't send it back or don't say anything to them about it, they assume that you're consenting through acquiescence. So basically, you're consenting because you didn't refuse, which don't make sense, but that's how they roll. And that's how they get jurisdiction to do, well, they don't have jurisdiction. That's how they take control and do a lot of illegal stuff that they do all the time. And this one is the notice of appeal template. When you file a notice of appeal, it's just a 1 or 2 page thing saying that you're appealing or whatever. It's not a big deal. Now, I have people that wanted to know if I can send them the appeal. Well, I don't do appeals. I only do the notice of appeal because I think it's great to use it as a tool to threaten the judge, so to speak. So when you file your notice to recuse and your notice of claim, you file your notice of reconsideration, your notice of claim, your notice of recuse, and then your notice of claim, then the last thing you should file is your notice of appeal. And you want to file your notice of appeal before the judge gets a chance to respond to any of that stuff. And once you file your notice of appeal, then what you're doing is you are actually taking the jurisdiction out of state court, because once you file a notice of appeal, then state court don't have jurisdiction unless they cure the problem. And so that's kind of the goal that you're shooting for. And if they don't, then you can just sue them for what's, at the end of the day, in my program, you're going to have to sue who's stopping you from getting what you need. And in most cases, it's going to be the judge. In my program, it's going to probably be the judge, because the judge usually interferes, and they don't want the attorneys to respond to any of this stuff because they don't know how. They can't respond. The notice of the challenge of jurisdiction, the jurisdictional challenge with an affidavit, they're having a really hard time responding to it. I just put together a new document that the online course students will be using to dismiss the case for failure to litigate the case. And that's what happens when. So you have to understand that their whole system is based off of fraud. So they can't come in and respond by counter affidavit. So that's a problem right there. If they can't respond by counter affidavit, then their response is lacking and they're in default. So if they haven't responded in the 14 days, then people need to move to court for default and file your motion to dismiss for failure to litigate the case. As long as you sit back and let the judge run the show, then the judge is going to stall for them. And there's a couple of people in our Facebook page. Dulce, she is in our Facebook page, and they're doing that to her. And her husband Adrian spoke up yesterday or the day before and told the judge that we're tired of waiting. We're not waiting anymore. And the judge still kind of made him wait. So she's getting ready to file her motion to dismiss because they're not ruling on their motion for summary judgment, and they haven't responded by counter affidavit because they can't. So they're trying to figure out what to do. They haven't had anybody spank them in the face like we're doing in our foreclosure rescue private Facebook page. And Shmel Maxwell, she's also used the jurisdictional challenge with an affidavit to not only stop the sale of her dad's house, she also vacated the default judgment. And once she did that, she filed her case and helped her dad file his case, wrongful foreclosure / breach of contract case in federal court. And what she's going to do is she's going to use that everything she filed in state court, she's going to use in federal court as evidence, because they couldn't respond. She challenged jurisdiction in state court. They couldn't respond. And if they couldn't respond in jurisdiction by counter affidavit, they're in default. So taking that and moving it into federal court and sticking that right in federal court's face, and you're like, well, now we don't need to have a hearing. We don't need to have interrogatories. We don't need to have all of that stuff. All we need to have is a settlement hearing, because they already are in default in state court and couldn't answer. They're not going to be able to answer here. Yeah, I love the way we do it. I love the way we do it. So that's what she's in the process of doing. And now the attorneys are fighting with the third party buyer, because the third party buyer wants their money back. And the third party buyer is pissed because they have not got their money back, and they're trying to get their money back. And this is interesting. So the attorney for the alleged lender contacted Shamel's dad and let him know that after he looked over the paperwork that he filed, his legal team saw that there were a lot of discrepancies, and they weren't going to foreclose on it. They weren't touching that no more. So I told her to tell her dad to let that dude know that their legal team has advised them not to talk to them, because the third party buyer may be added as a party to the action. Because remember, in the right hand corner underneath the case number, you reserve the right to amend. And that's when you add the people you need to add extra above the 3 people. So you don't have to serve all these people, and you don't have to respond to all these people and do all this stuff. Then you add them at that time. And I told them to make sure that they let the third party buyer know that they may have to include him in the $5.5 million lawsuit in order to make the $5.5 million up that they need to have. And she said that when they told him that, his eyeballs almost popped out of his head.
You're beating them at their own game, Coach. That's what you're doing. And that's what I love about it.
Well, actually, I'm helping them beat them at their own game with phone calls and text messages. Okay. I don't need to charge nobody, $50,000 and $200 a minute. No. And I'll tell you what, for the people that have stepped up, it really makes my day, because all the work and all the, that have gone into putting myself in a position to help others now is reflected in seeing the success that people are starting to have. And I have people in other Facebook pages always, well, what case law, what have you won? Show me the cases that you won. Dude, it's not about winning anything. It's about getting to stay in your house.
Yep.
Because winning means the judge is going to give you everything and all of that. And that ain't never going to happen. That is never going to happen. So it's about getting to stay in your house. So you need to do whatever you need to do to get to stay in your house. And that's what we're doing here with helping people with the program that we've got going on here. Mm-hmm. And it's been working out very well.
I think it has been. You got about 2 minutes and then you're good.
Okay. So I want to let you guys know again that you can reach my website is winincourtnow.com. And all of my lawsuit packages are on the website, and I need to go to the website and change that. I forgot to do that before we went online, so that it will already be marked down. When you purchase this package, it'll be downloaded to the email address that's connected to your payment method. So if you don't find it, then you might check there. You might check the download, the download file. And sometimes people have to check the spam folder. And sometimes people have to check the spam folder to find it. Now, when you click on it, it opens up into, it looks like it's one document, then you click on it a second time, and then it opens up into the document to show all of the documents that's in the package. And I'm going to mark this package down to $100 as a way of showing what I'm doing. This lets you know that I'm standing behind what I'm doing. And I want to see how people respond to it. I want to see how the judge tries to get out of this so that I can, because you see, I only have 4 documents in it or whatever. And I don't think I'm going to need any more, but I won't know until people start using it. So I need people who have the courage to step up and hold these judges accountable to come up with that $100. It's going to be the best $100 you can spend, because this is going to help you be able to anytime they drag you, no, they're not going to want to drag you in court when you get done. Your name will be on the list up there. Don't mess with this dude or do that. Huh? So again, I want to thank you, Gene, for having me on the show and giving me an opportunity to communicate with everybody.
You're
and
welcome.
all the people that are listening and called in. And having this on here for $100 is my way of showing my appreciation for everybody following me. And there's one more thing that I want to show before we go.
Good, you got time. You got, I can give you a couple extra minutes. I don't have a problem with that.
And that will be maybe. Let's close that up. And we'll close that up. Okay, here we go. One more thing I want to show, and that's my YouTube channel here. I only need like 19 more people to subscribe to hit this qualification. And I'm almost about to hit 3,000 here. I need 4,000. And I think the last 700 or 800 came within 2 or 3 weeks. So at the end of the month, I could be in a position to contact them and see if all the qualifications are met so I can host ads on my channel and start generating some mucho dinero. So I want to thank everybody for subscribing and supporting me, and just to show you how well it's going.
Oh, and I got some news to share real quick. This isn't really good news, but this is news nonetheless. We've all been communicating with emails for a real long time. Everybody has websites, have their own email for their domain, for the email. The problem is all the servers for the email domains aren't going to be doing emails anymore. So if you want to email, you're going to have to either use the main Gmail, Yahoo, AOL, or a couple others, but a lot of them are going away, which means that if nobody has an email to communicate with, where they're going to go? To all them other emails. So if you need an email, get your email now, because you may not get one later. They may start sanctioning them off because they're only limited to certain servers. The problem with that is too much spam and not enough people using the emails going to social networks, contacting people through chats. And again, I said spams, they cut it off because they're not making a lot of money on the emails. So that's one of the reasons why they stopped it. Does that make sense? And there's no security on the emails anymore like there used to be. So they filter everybody's email out unless you go into your filter and change your filter settings, which is something else you might need to do. So you can see Coach Neighbors, so you can see Hamilton Radio. They've banned us many times already. I've got friends that said, I haven't got an email here from 30 years. I'm like, really, for 30 years? I mean, I've been doing emails for forever. So I'm changing my email because I'm not getting a lot of the emails either. So if you need to email me, you need to contact me at gdpent1@yahoo.com. That's G as in George, D as in David, P as in Paul, E as in Edward, N as in Nancy, T as in Thomas, with the number 1 at yahoo.com. My admin at hamiltonradio.net won't be working anymore. It's going to be gone. They're phasing it out. Okay, that's why I'm telling you guys this. Go get an email now wherever you can, Gmail, whatever you want to do, because there's going to be a lot of people flocking to them sites to get emails, and they're going to be rationing them off and say, no, we can't do any more emails because the servers are only so big. So does that make sense to you, Guy?
Yep.
Yeah, that's why I'm giving that heads up to everybody. So I want to thank you for, again, being here. And please take what we say as this is what we're fighting against. We're fighting against this because we believe in what he's doing. I believe in what I'm doing. And we believe together we can at least save our homes. And I think that's the bottom line.
Yep,
So,
that's the bottom line. And
right.
for $100 a day, you can get something to stick in a judge's face.
I love that. Let's slap all the lawyers in the face. I totally agree. All right. Thanks, Coach Neighbors. Let me end the broadcast, and then I'll talk to you for a second.